The bright lights of the Fox News studio illuminated Congresswoman Jasmine Crockett's determined face as she prepared to face Mark Levin, the conservative radio host known for his fiery rhetoric and unwavering support for traditional legal interpretations. Just moments earlier, Levin had confidently declared on air these Democrats know nothing about constitutional law, especially that freshman congresswoman. The audience gasped, some clapping, others shaking their heads in disapproval. Crockett, the former civil rights attorney and first-term representative from Texas, sat calmly in the green room, watching the monitor, her law books beside her. Unlike many political figures who might shrink from Levin's notorious intimidation tactics, Crockett's eyes reflected not fear, but focus. A Harvard-educated lawyer with years of courtroom experience before entering Congress, she saw this not as an attack, but as an opportunity. "We're live in 2 minutes, Congresswoman," the producer announced. Crockett nodded, gathered her notes, and stood up. This wasn't just another cable news debate. This was her moment to expose Levin's legal misconceptions in front of millions. Before we continue this explosive confrontation, like and subscribe so you never miss another moment of political truth being served. Now, let's see what happens when one of Fox's favorite legal commentators faces a congresswoman with actual courtroom experience. Mark Levin sat comfortably in the main chair on set, his signature scowl firmly in place. The 65-year-old conservative icon had spent decades building his reputation as a constitutional expert. With his syndicated radio show, The Mark Levin Show, and his Fox News program, Life, Liberty, and Levin, he had become a household name for millions of conservative Americans. His books on constitutional law had topped bestseller lists, and his opinions carried significant weight in Republican circles. Today, Levin wore a navy suit that contrasted with his stern expression, his glasses perched on his nose as he reviewed his talking points. The topic: the recent Supreme Court ruling on presidential immunity that had divided legal scholars across America. Levin had been vocal that the court's decision was perfectly aligned with the Founding Fathers' vision, a position many constitutional lawyers disputed. Mark has been absolutely relentless on this immunity issue, the host introduced. He's argued that anyone questioning the expansive view of presidential power is ignoring the Constitution itself. The camera panned to show Levin nodding firmly, his face a picture of absolute certainty. "That's right," he said, his voice carrying the gravitas of someone who believed his interpretation was beyond question. "What we're seeing from the left is a fundamental misunderstanding of Article 2 powers. They don't understand the basic separation of powers that the founders established." The split screen showed Congresswoman Jasmine Crockett entering the studio, her composed demeanor a stark contrast to Levin's intensity. At 42, Crockett represented a new generation of leadership. Before her 2022 election to Congress, she had built a reputation as a formidable civil rights attorney in Texas, winning difficult cases and establishing legal precedents. Her law degree from Harvard and years arguing constitutional matters in federal courts made her uniquely qualified to discuss the very issues Levin claimed Democrats couldn't understand. Joining us now is Congresswoman Jasmine Crockett of Texas, the host continued. "Congresswoman, you've heard Mark's position that Democrats are misinterpreting the Constitution regarding presidential powers. Your response? What viewers didn't know was that Crockett had spent the previous night reviewing not just the recent Supreme Court decision, but also Levin's own writings and statements over the past decade. She had identified numerous contradictions and errors in his legal reasoning, inconsistencies that proved his positions were more political than constitutional. She had also brought actual case law citations, something Levin often glossed over in favor of broad historical statements. The stakes couldn't have been higher. This wasn't just about a single Supreme Court decision or scoring political points. It was about who had the authority to interpret the Constitution, and whether political commentators should be held to the same standards of accuracy as practicing attorneys. For millions watching at home, this confrontation would either reinforce or challenge their understanding of presidential powers and constitutional limitations. Crockett adjusted her microphone and smiled slightly. "Thank you for having me. I've been listening to Mr. Levin's analysis with great interest, particularly given my background litigating constitutional issues in federal court." Levin interrupted immediately, his voice rising. "Your experience doesn't compare to decades of constitutional study. I've written books on this subject that legal scholars reference." Crockett's expression remained unchanged as she replied, "Well, Mr. Levin, that's exactly what I'd like to discuss today. The difference between studying law and practicing it. in actual courtrooms where real judges evaluate real precedents. The tension in the studio became palpable. This wouldn't be the typical cable news shouting match. It was about to become a masterclass in constitutional law, one that would leave one of them exposed. "Let's get right into it," the host said, sensing the building tension. "Mark, you've stated repeatedly that the Supreme Court's recent ruling on presidential immunity is exactly what the framers intended. Congresswoman Crockett, you disagree?" Levin jumped in before Crockett could respond. "This isn't complicated," he stated firmly, his voice rising as it always did when he felt passionately about a topic. "The Constitution establishes a unitary executive. Article 2 vests all executive power in the president, not some, all. The founders never intended for presidents to be constantly harassed by prosecutors and courts for their official acts. This is basic separation of powers." He leaned forward, his face reddening slightly. "Anyone who's actually read the Federalist Papers, which I doubt the Congresswoman has done recently, would know that Hamilton and Madison were crystal clear on this. Presidential power cannot function if it's constantly undermined by the other branches." Crockett waited patiently for Levin to finish, jotting down notes as he spoke. When the host finally turned to her, she smiled slightly. "Well, it seems Mr. Levin and I have different copies of the Constitution and Federalist Papers," she began calmly. "Because mine doesn't include the word immunity anywhere. In fact, the founders were explicitly concerned about creating a president who was above the law. That's precisely what they had rejected in breaking from the monarchy." Levin scoffed loudly. "That's a simplistic reading that ignores historical context." "I'm happy to provide the historical context," Crockett continued undeterred. "Federalist 69, which you referenced, actually draws a sharp distinction between the American president and the British king, precisely because the president would be accountable to the law. Hamilton wrote that the president, unlike the king, could be impeached, tried, and, upon conviction, removed from office, and then would be liable to prosecution and punishment in the ordinary course of law." She pulled out a copy of the Federalist Papers with highlighted sections. "I have the exact quote here if you'd like to see it, Mr. Levin." The camera caught Levin's momentary hesitation. He hadn't expected such a specific citation. "Well, that's about impeachment, not criminal prosecution," he countered, shifting in his chair. "You're missing the broader constitutional structure." "Let's talk about that broader structure then," Crockett replied, her tone remaining professional but firm. "You've repeatedly claimed on your show that the vesting clause of Article 2 provides absolute immunity. But in 1982's Nixon v. Fitzgerald, a case I've actually argued before federal judges, the Supreme Court explicitly stated that presidential immunity is not derived from any explicit constitutional text." Those are their words, not mine. The host, seeing Levin growing increasingly agitated, tried to intervene. "Mark, how do you respond to the Congresswoman's citation of specific case law?" Levin's voice grew louder. "Case law doesn't override the Constitution itself. This is exactly what's wrong with how the left approaches constitutional interpretation. They rely on flawed precedents rather than the document's original meaning." "But Mr. Levin," Crockett interjected, "isn't it true that in your book, Men in Black, you actually criticized judicial supremacy? Yet now you're arguing that the Supreme Court's recent decision is beyond question. It seems your position changes depending on whether you agree with the outcome." The studio grew tense, as Levin visibly bristled. "Don't presume to lecture me about my own writings. You're taking things out of context." Crockett calmly opened a copy of Levin's book. Page 47, you wrote, and I quote, "The court's constitutional decisions are final only if the other branches and the people accept them as final. I'm simply wondering why that principle doesn't apply when the ruling favors your preferred outcome." Levin's face reddened further. "That's a completely different context. We're talking about presidential immunity here." "Yes, we are," Crockett agreed. "And in 2020, when discussing the Trump administration, you claimed that presidents should have robust immunity. But in 2014, when discussing President Obama's executive orders, you argued that presidential actions should be heavily scrutinized and checked by the courts. I'm trying to understand the constitutional principle that allows for these opposing views." The host sensed a ratings moment developing. "Let's be specific here, Congresswoman. Are you suggesting that Mr. Levin's constitutional interpretations change based on which party holds the White House?" Crockett maintained her composed demeanor. I'm simply pointing out inconsistencies in his legal reasoning. As a practicing attorney who has argued constitutional issues in federal court, I know that consistency matters. Judges would immediately question an attorney who argued opposing principles in different cases. Levin, clearly frustrated, raised his voice further. This is absurd. You're cherry-picking statements without understanding the nuance of different constitutional scenarios. Perhaps we should look at specific scenarios then, Crockett suggested. She pulled out another document. In 2016, you stated that executive privilege should be narrowly construed when President Obama invoked it. In 2022, you argued it should be broadly interpreted when former President Trump invoked it. Same constitutional principle, opposite interpretations. The camera caught Levin shuffling papers, looking increasingly uncomfortable. You can't compare those situations. The contexts were completely different. The legal principle remains the same, Mr. Levin, Crockett pressed on. That's how constitutional law works. It applies consistently regardless of who's in office. That's what I tell the judges when I appear before them. The tension reached a new height as Levin pointed his finger at Crockett. You don't understand constitutional law if you think it's that simplistic. Context matters. I agree that context matters, Crockett responded calmly. That's why I'm providing the full context of your statements. Would you like me to continue with more examples? The host, sensing Levin's growing discomfort, decided to intervene. Let's take a quick break and continue this discussion when we return. We're talking with Mark Levin and Congresswoman Jasmine Crockett about presidential immunity and constitutional interpretation. Stay with us. As the cameras cut to commercial, Levin could be seen removing his microphone and speaking angrily to a producer, while Crockett remained seated, reviewing her notes. The confrontation was escalating, but the most dramatic moment was yet to come. When the broadcast resumed, the tension in the studio had visibly increased. Mark Levin had composed himself but appeared more rigid than before. Congresswoman Crockett maintained her calm, professional demeanor, her legal documents neatly arranged before her. Welcome back, the host said. We're discussing the constitutional foundations of presidential immunity with Mark Levin and Congresswoman Jasmine Crockett. Mark, you wanted to clarify your position? Levin nodded stiffly. Yes, the congressman is playing politics by selectively quoting me across different contexts. What matters is the constitutional principle, which has remained consistent in my work. The presidency must have sufficient authority to function as the founders intended. That's a fair point about context, Crockett acknowledged. So let's focus on one specific constitutional question. Does the Constitution provide absolute immunity to presidents for official acts? You've claimed it does. I'd like to examine that claim strictly on its legal merits. The Constitution establishes a unitary executive with full Article II powers, Levin replied, seeming relieved to return to his familiar talking points. The president cannot function if constantly threatened with prosecution. Crockett nodded, then reached for a document. I have here the transcript from the recent Supreme Court oral arguments on presidential immunity. Even the conservative justices expressed concerns about absolute immunity. Justice Barrett specifically asked about a president who ordered SEAL Team 6 to assassinate a political rival. Under your interpretation of absolute immunity for official acts, would that president be immune from prosecution? Levin hesitated. That's an extreme hypothetical that does... It's not my hypothetical, Crockett interrupted politely. It came from Justice Barrett. How would you answer her question? Obviously, that would be an illegal act, Levin conceded. So there are limits to presidential immunity for official acts? Crockett asked. Because you've stated repeatedly on your show that the Constitution provides absolute immunity for all official acts. You're twisting my words, Levin shot back. I've always recognized that criminal acts wouldn't be covered. Crockett's expression remained neutral as she pulled out another document. On your March 15th broadcast, you stated, and I quote, "The Constitution gives the president absolute immunity for all official acts, period. Anyone saying otherwise doesn't understand Article." Would you like to revise that statement now? The camera caught Levin's face freezing momentarily. He hadn't expected her to have transcripts of his recent broadcasts. Context matters, he insisted, his voice strained. I was speaking about legitimate official acts, not criminal behavior. But that's precisely the constitutional question at issue, Crockett pointed out. What defines a legitimate official act versus an illegitimate one? The Constitution doesn't make that distinction in the text. Levin began to look increasingly uncomfortable. This is why we have constitutional interpretation. Exactly, Crockett agreed. Which is why absolute statements about what the Constitution clearly provides are problematic. The document requires interpretation, as you've just acknowledged. Then came the moment that would later go viral across social media. Crockett reached for another document. Mr. Levin, you've repeatedly claimed to be an authority on constitutional law. May I ask where you practiced constitutional law? Levin blinked. I was Chief of Staff to the Attorney General of the United States. I've written multiple New York Times bestsellers on constitutional law. So you haven't actually practiced constitutional law in court? Crockett pressed gently. I've analyzed it at the highest levels of government, Levin replied defensively. Crockett nodded. I respect your government service. But there's a difference between analyzing law and practicing it. Before Congress, I litigated constitutional issues in federal court, arguing before judges who tested every claim against precedent and text. When you make a legal argument in court, you can't simply declare what the Constitution clearly says. You must substantiate it with text, history, and precedent. She paused. For example, you've claimed that U.S. Nixon was wrongly decided, but that was a unanimous decision, including justices appointed by Nixon himself. What specific legal error do you believe all 9 justices made? Levin's expression tightened. They misunderstood the unitary executive theory and the scope of executive privilege. Could you cite the constitutional text or founding-era evidence they overlooked? Crockett asked, because the court specifically examined the debates from the Constitutional Convention and found no support for absolute privilege. Levin shuffled papers without finding the reference he needed. The court prioritized the criminal justice system over the constitutional structure. Actually, Crockett continued, displaying a document, Chief Justice Berger wrote that the Constitution does not place the president above the law. He cited James Wilson, who told the Pennsylvania Ratifying Convention that not a single privilege is annexed to character. These were the founders' words that informed the unanimous Nixon decision. The studio fell silent as Crockett continued. But what's most revealing is your own inconsistency on Nixon. In 2011, discussing Obama, you cited Nixon approvingly. In 2019, discussing Trump, you called it fundamentally flawed. Same case, same constitutional principles, different presidents. The camera captured Levin's growing discomfort as Crockett displayed side-by-side quotes from his own broadcasts. The Constitution doesn't change depending on who's president, Mr. Levin, she said quietly. That's not constitutional interpretation, it's political advocacy disguised as legal analysis. Levin, visibly flustered, raised his voice. You don't have the background to question my constitutional expertise. I've spent decades. I'm not questioning your expertise, Crockett interrupted calmly. I'm questioning your consistency. Constitutional principles either apply universally or they're not principles at all. Then came the moment that would dominate headlines. Crockett held up a legal textbook. This is Constitutional Law by Chemerinsky, the standard text in law schools across America. I've brought specific citations contradicting your claims about presidential immunity. Would you like to address them? Levin stared at the book but didn't reach for it. Erwin Chemerinsky is a liberal academic whose work is cited by the Supreme Court regularly, including by conservative justices, Crockett completed. Legal analysis requires engaging with authoritative sources, even when they challenge our preferences. That's how the law works. The host, sensing a pivotal moment, intervened. Congresswoman, are you suggesting Mr. Levin's analysis lacks legal foundation? Crockett shook her head. I'm suggesting there's a difference between political commentary and legal analysis. Mr. Levin has every right to his political views, but presenting those views as definitive constitutional interpretation misleads viewers who deserve accurate information about our founding document. She turned directly to Levin. The Constitution is neither liberal nor conservative. It doesn't belong to either party. When we distort it for political purposes, we undermine the rule of law itself. Levin, for perhaps the first time in his broadcasting career, appeared genuinely at a loss for words. The camera captured his stunned expression as he struggled to formulate a response. The Congresswoman is entitled to her opinion, he finally managed, his voice having lost its characteristic certainty. But the founders would disagree with her limited view of presidential authority. Perhaps, Crockett replied, but provided their actual words while you've offered your interpretation of what they would think. That's the difference between evidence-based legal analysis and political commentary. The host, recognizing the dramatic shift in dynamics, turned to the camera. We'll take another break and return for final thoughts from our guests on this remarkable discussion about constitutional interpretation. As the program cut to commercial, social media was already erupting with clips of Crockett methodically dismantling Levin's constitutional claims. The hashtag #CrockettSchoolsLevin began trending nationwide, with legal experts and viewers alike expressing astonishment at the precision of her constitutional breakdown. What had begun as another cable news debate had transformed into something unprecedented, a masterclass in constitutional law that exposed the difference between political talking points and substantive legal analysis. When the broadcast resumed, the shift in dynamic was unmistakable. Mark Levin sat stiffly, his usual domineering presence noticeably diminished. Congresswoman Crockett remained composed, her evidence-based approach having fundamentally altered the conversation. We're back with our final segment, the host announced. Congresswoman Crockett, your closing thoughts on presidential immunity and constitutional interpretation? Crockett nodded thoughtfully. The Constitution creates a president, not a king. The founders rejected monarchy precisely because no one should be above the law. When we discuss immunity, we're really asking whether power should have limits in a democracy. The text, the history, and 2 centuries of jurisprudence all suggest it must. That's not a partisan position, it's the foundation of our constitutional republic. The host turned to Levin. Mark, your final thoughts? Levin had regained some of his composure during the break, but his typically absolute tone was notably absent. The presidency requires certain protections to function effectively. That's a constitutional necessity regardless of who holds the office. We can debate the extent, but the principle remains valid. Thank you both for this illuminating discussion, the host concluded, clearly aware that viewers had witnessed something unprecedented. As the broadcast ended, the real impact was just beginning. Within minutes, clips from the exchange flooded social media platforms. Constitutional law professors shared the video in their classes. Legal blogs analyzed the confrontation in detail. The hashtags #CrockettSchoolsLevin and Constitutional Smackdown trended nationally. On Twitter, a prominent legal scholar posted, "Just watched Congresswoman Crockett give a masterclass in constitutional law to Mark Levin. As someone who teaches this subject, I'm stunned by her precision and knowledge of case law. This is how constitutional debate should happen." A viral clip showing Crockett calmly asking Levin where he had practiced constitutional law, followed by his uncomfortable response, garnered millions of views overnight. Law students created memes comparing Crockett's evidence-based approach to Levin's rhetoric. CNN's legal analyst observed, "What we witnessed wasn't just a political disagreement. It was the difference between someone who has actually stood before federal judges making constitutional arguments and someone who has talked about the Constitution on television. The contrast couldn't be more stark." Fox News initially attempted to minimize the exchange, but the viral nature of the clips made it impossible to ignore. Conservative legal scholars found themselves in the awkward position of acknowledging Crockett's constitutional points while trying to defend Levin's broader political positions. The Washington Post ran an analysis piece titled, "When Political Commentary Meets Actual Legal Expertise, the Crockett-Levin Moment Explained." The article detailed how Crockett's courtroom experience had provided her with a fundamentally different understanding of constitutional interpretation than Levin's media-based approach. In the days that followed, Levin addressed the confrontation on his radio show, attempting to reframe the discussion. The Congresswoman came with selective quotes and liberal interpretations, he insisted to his audience, but the broader constitutional principles I've outlined over decades remain valid. However, his defensive tone did not escape notice. Listeners observed that he avoided directly addressing Crockett's specific points about the Constitution's text and history regarding presidential immunity. Crockett, meanwhile, used the moment to elevate the conversation about constitutional literacy. In a CNN interview, she emphasized, "This isn't about partisan politics. It's about ensuring Americans understand what their Constitution actually says versus what political commentators claim it says. The document belongs to all of us, and we should engage with it honestly, regardless of our political preferences." Law schools across the country requested Crockett as a guest lecturer on constitutional interpretation. Her office reported being flooded with invitations to speak about the relationship between law and politics. Several legal organizations highlighted the exchange as an example of how constitutional debates should incorporate actual legal analysis rather than political talking points. The confrontation sparked a broader discussion about expertise and credentials in public discourse. Media critics noted how often political commentators presented themselves as constitutional experts without formal legal training or experience. Law professors pointed out the dangers of conflating political preferences with constitutional requirements. Perhaps most significantly, viewers across the political spectrum began questioning other constitutional experts in media, asking about their actual legal credentials and experience. A new standard seemed to emerge. Those claiming constitutional expertise were increasingly expected to substantiate their claims with specific citations and consistent principles. For Crockett, the moment transformed her national profile. Previously known primarily as a freshman representative, she was now recognized as a formidable constitutional voice. Senior Democratic leaders began consulting her on legal strategy, and her committee assignments gained new significance. For Levin, the confrontation presented a challenge to his carefully cultivated image as a constitutional authority. While his core audience remained loyal, legal professionals and more moderate viewers began scrutinizing his constitutional claims with greater skepticism. The exchange even reached law enforcement agencies, where officials discussed the actual constitutional limitations on presidential power with renewed interest. Constitutional law professors reported students bringing up the Crockett-Levin exchange in class discussions about executive power and immunity. The most lasting impact, however, was on public discourse itself. In the weeks following the confrontation, cable news producers noted a subtle shift in how constitutional issues were discussed. More programs began featuring actual constitutional law professors and practitioners rather than political commentators when discussing legal issues. Viewers seemed to expect a higher standard of evidence when constitutional claims were made. As one media observer noted, Crockett didn't just challenge Levin's specific claims, she challenged the entire ecosystem of political commentary masquerading as legal expertise. And judging by the response, viewers are hungry for that distinction. 6 weeks after the exchange, when another constitutional controversy emerged, social media users demanded Crockett-level evidence from commentators making constitutional claims. A new benchmark had been established. The confrontation between Crockett and Levin ultimately transcended the individuals involved. It became a case study in how democratic societies should engage with their founding documents, not through political convenience or partisan advantage, but through rigorous, consistent interpretation based on text, history, and precedent. As one constitutional scholar summed it up, in 30 minutes of television, Congresswoman Crockett accomplished what legal educators have been trying to do for years. She showed that the Constitution is neither liberal nor conservative. It's a legal document that deserves honest interpretation regardless of our political preferences. That's the true constitutional lesson. If you found this breakdown of the Crockett-Levin constitutional showdown illuminating, don't forget to like this video and subscribe to our channel. We bring you the most important political confrontations with detailed analysis that goes beyond the sound bites. Hit that notification bell to never miss another moment when political talking points meet genuine expertise head-on. More net below with your thoughts on who really understands the Constitution better.